Ever wondered what happens if a loved one's will just doesn't seem right? Or worse, what if you suspect foul play in its creation? Well, challenging a will is no easy task, but understanding the law gives you an edge. In this video, I'll break down everything you need to know about how to challenge a will in India step by step. Stay with me because there are ways to protect your rights and ensure justice. Challenging a will can feel overwhelming, especially when emotions running high after a family member's death. A will is a legal document that ensures the deceased wishes are honored, but sometimes wills are questioned due to fraud, coercion, or procedural mistakes. The Indian Succession Act of 1925 lays down the rules, but what are the valid reasons to contest a will? In this video, I'll cover first, the key legal grounds for challenging a will. 2. What to do if you find yourself in a dispute over a will. 3. Relevant case laws and recent developments to give you clarity. So, let's dive right in. Here are the primary grounds to challenge a will in India. First, lack of testamentary capacity. Was the person mentally fit to make the will? 2. Undue influence or coercion. Was the will written under pressure? 3. Fraud or forgery. Are there any false representations? 4. Improper execution. Does the will follow legal procedures? 5. Suspicious circumstances. Is the content of the will questionable or inconsistent? Now, let's explore each of these points in depth. Before a will is considered valid, the testator, meaning the person making the will, must be of sound mind. This means they should understand what they are doing, be aware of their assets, and know who their legal heirs are. If the person was suffering from a serious mental condition like dementia or was under heavy medication, the will can be contested. In the case of Rani Purnima Devi versus Kumar Kagendra Narayana Dev, the court held that mental incapacity can invalidate a will. If the testator was forced or manipulated into making the will in someone else's favor, it is a ground for a legal challenge. Undue influence often occurs when the person is vulnerable, such as an elderly individual under the care of someone with bad intentions. Justice S.P. Barucha once noted in a ruling that coercion disguised as care can have devastating legal effects. If a will is forged or created with false information, it becomes invalid. For example, if someone adds clauses after the testator has signed the will or uses deceit to obtain their signature, it counts as fraud. In the case of H. Venkatachalaya Iyengar versus B. N. Timajamma, the court emphasized that fraudulent wills are null and void. The Indian Succession Act requires that a will be signed by the testator and witnessed by at least 2 people. If this procedure isn't followed, the will be legally challenged. Many wills get struck down simply because they are not properly witnessed, even though the intent behind them was genuine. Sometimes the will's contents raises doubts. For example, if a will completely excludes natural heirs without any explanation, or if the distribution is highly unusual, the court may investigate further. If you believe a will is invalid, here's what you should do. First, consult a lawyer specializing in succession law. A legal expert can analyze the will and determine the strength of your case. 2. File a caveat in the probate court. This prevents the probate process from moving forward without notifying you. 3. Gather evidence. Collect any medical records, witness testimonies, or financial documents that support your case. 4. File a suit in court. If your case is strong, you can file a suit under the Indian Succession Act 1925 to contest the will. 5. Consider mediation. If family relations are strained, mediation can help solve disputes without going to court. In a recent judgment, the Supreme Court emphasized that courts should be cautious in cases involving undue influence. In Mahesh Kumar versus Vinod Kumar, the court ruled that the burden of proof shifts to the beneficiary if there is a prima facie evidence of coercion. Also, amendments to the inheritance laws now give greater weight to testators, explaining the reasons for excluding their heirs. So, always look out for such explanations within a will. Let's quickly recap the key points. First, lack of capacity. The person making the will must be of sound mind. 2. Undue influence. Coercion makes the will invalid. 3. Fraud and forgery. Any fraudulent element voids the will. 4. Improper execution. Legal procedures must be followed. 5. Suspicious circumstances. Inconsistent or unjust content invites scrutiny. Challenging a will may seem daunting, but if you act quickly, follow the legal steps, justice is possible. Don't forget to consult an experienced lawyer and document everything carefully. If you found this video helpful, hit the like button and share it with someone who might need it. Subscribe to the channel for more legal insights and drop your questions in the comments. I'd love to help you out. Take care and bye-bye.
Living life, every day, late at night, not okay. All I want, and I pray, all I need are some better days. Fuck me, I'm looking in the mirror, so foggy, but I've never seen clearer. I don't really think anyone can save me, and honestly I'm not really sure I want saving. I like to be my own worst enemy. There's no risk if you don't try at anything, so I'ma just keep buying everything. See you in the next life, have to be a better me. I don't